entrepreneurs can be crazy. And these studies show a very strong correlation between entrepreneurs, successful entrepreneurs, and sociopaths, serial killers. There are 7 steps to setting up a small business. First of all, you have to find a name for the business. Secondly, you have to determine if any business licenses are necessary. You got to make sure that your client understands who they're dealing with. It is a big mistake to accept money from somebody who has a hidden agenda, and sometimes they do. Be very careful. Investors always ask for the moon, the sun, and the stars.
Welcome, and thank you all for joining us for another Justia webinar. To kick things off, I want to go ahead and introduce our speaker, Cliff Ennico. Cliff Ennico is a leading expert in legal and tax issues for entrepreneurs, known for hosting Money Hunt on PBS and writing the syndicated column Succeeding in Your Business. He is also the author of many books on entrepreneurship, crowdfunding, and small business law, as well as legal treatises for Thomson West. With a 45-year legal career, he has represented over 15,000 small businesses and previously worked at top NYC law firms before establishing his own practice in Fairfield, Connecticut. He is a Dartmouth and Vanderbilt Law graduate and an active speaker, YouTube host, and contributor to Entrepreneur and other business publications. The webinar presentation that you're about to watch will be approximately 1 hour. And once that's complete, Cliff will be taking questions from the audience. So if you have questions that come up, please feel free to submit them by clicking into the Q&A button in the control panel at the bottom of your screen and sending them in there. Now, without further ado, here is Cliff to discuss representing the small business clients.
Hey, thanks, Tina, and that was such a wonderful introduction. The nice thing about my introduction is it takes half of the program. It takes up half of the program time, which is good. It makes my life a little bit easier here. Welcome to all of you for attending today's program. We're going to be talking today about representing the small business client. This is not going to be jurisdiction specific in any way. Obviously, corporations and LLCs are formed differently in each state of the union, and you always have to look at your own state laws to determine exactly what you have to do. But we're going to be covering the basics in the program, and it will cover the law in most of the states that you will ever deal with. Every lawyer should know how to represent a small business or a startup enterprise. Now, those are 2 very different things, and we're going to talk about the difference in a minute. The advantages of practicing in this area is it's one of the few places in the law where you can still be a legal generalist. People ask me at parties, "Hey, Cliff, what type of law do you practice?" And I say, well, I practice 36 different areas of the law. I represent small business and entrepreneurial clients, and I'm really like their internist, their general practitioner. I'm their general counsel until such time as they can afford to bring on somebody full-time to perform that role. You're also making something positive happen in the world. Let's face it, all of us went to law school at some point because we wanted to make a difference in the world. And this is one of areas of practice where you really can do that. I liken what I do to being a maternity ward nurse in a hospital. All the other nurses and doctors are seeing death, disease, people dying of cancer, COVID, whatever. I am seeing people going home with babies. I'm seeing positive things happening to people, at least when they succeed. And I'm very proud of that. I can actually drive down my local commercial strip here in Connecticut, and I can point to businesses that I helped through a tough patch and that probably wouldn't be there if I hadn't been there at a critical moment in their development. So it's just a nice practice to be in. But there are negatives, like just as there are in any practice at all. Entrepreneurs can be crazy. There are actually some statistics. There's actually some published research, some neurological research, the kind of thing where they put nodes on people's heads and measure their brain waves and how they react to different stimuli and stuff like that. There is a very strong correlation. These studies show a very strong correlation between entrepreneurs, successful entrepreneurs, and sociopaths, serial killers. It's amazing. I've given you the link to one of these studies, but if you just search online for entrepreneurs versus sociopaths, you'll probably get to some links to some of the research that is out there. They can be time vampires. They do not respect the clock. When I get a call on Saturday night and then they expect a return call on Sunday, that's almost invariably one of my entrepreneurial clients. Egos are sometimes out of control. Show me someone who's built $100 million business from scratch, and I will show you somebody with a colossal ego that has to be managed. They move at internet speed. They're not always the nicest of people. I have to say that. I have a YouTube channel, as Nina very nicely pointed out, and I actually have a whole video on the psychology of entrepreneurship. It's called the 3 personality traits every entrepreneur needs to develop if they're going to run a business of their own. If you go to youtube.com and search for Cliff Ennico, you'll see all of my videos. I got about 55 things up there. They're all 1-hour videos. By the way, none of my YouTube videos are accredited for CLE credits. These are programs that I do for the general public, not for lawyers. So you're not going to get CLE credits out of those like you will this one. But if you search for Cliff Ennico personality traits, you'll probably get right to the 1-hour video that I'm talking about. Stick around for the entire 1 hour because I talk about some things that are not in any of the published literature, just my observation of working with entrepreneurs for 45 years of my life. Also, clients are watching every penny and expect you to do the same. This is not a client where you can run up a huge receivable. You got to be very careful about managing your costs and your time with a client like this because they very often cannot afford to pay, you what you're really worth. So let's talk about this. I'm using the terms small business and startup interchangeably, but that's really not true. They are 2 very different kinds of entity. They're 2 very different kinds of client, and their legal needs are very different. By a small business, I'm referring to a business that's usually in a retail or service business, a business that's non-scalable. Now, what do I mean by that? A non-scalable business, that's an economic term, and it basically means that in order to grow the business, you have to keep inputting cash and capital. A law practice is a non-scalable business. If I want to grow my practice, there's only 24 hours in a day. Either I have to bill more hours or I have to hire people to bill more hours. That's the only way that I can grow that practice. The growth curve for a non-scalable business is a straight line. The market for a small business is usually local or regional. It can sometimes be hyper local. I represent a number of fitness centers, gyms. Obviously, I don't belong to any of them, but I do represent a bunch of them. And statistics show that 95% of a gym's customers come within a half a mile of where the gym is located. So sometimes a small business can have a very hyper local market. I know small businesses in New York City and Manhattan whose primary clientele are the 2 office buildings on either side of the store. I mean, it can be that narrow. In a small business, the owners and the workers are the same. There is no distinction whatsoever between labor and capital. The person who is slicing your bologna at the local deli is also a 20% owner of the closely held corporation that runs the deli. And small businesses are not designed to grow big or sell. They are designed to be around for the long haul. If it's a family business, they're around to create a legacy for the business family members. I am representing some companies that have been around for over 100 years, although I wasn't around when they were first incorporated, but I'm representing now the 3rd or the 4th generation of people that are running that family business. Now, startups, tech companies are very, very different. A startup enterprise is usually a manufacturing or technology business. That's a business that is scalable. What that means is that in order to grow the business, you don't always have to keep putting in capital on an ongoing basis. Sooner or later, the business becomes self-sustaining. The growth curve for a startup enterprise is a parabola if it succeeds. Those of you who remember your high school algebra, a parabola. The market is usually national or global in scope. The owners and the workers are not the same. Unlike a small business, startup enterprises have passive investors. They have investors who just put their money in and they're not expected to work in the business. I own some shares of Microsoft. Bill Gates does not have the ability to call me on a Sunday and ask me to come in and do some coding. He does not have that ability. I'm just a passive investor. I'm just looking for a return on my investment. I'm not part of the management in any manner, shape, or form. They are designed to grow big, and they're also designed to eventually exit. And there's only 2 ways that a startup enterprise can exit. They can either go public, launch an IPO, register with the Securities Securities and Exchange Commission in Washington, or more commonly, they sell to a much larger company and become the XYZ division of Microsoft, X, Google, whatever. And usually this happens within 5 to 10 years of the company's formation. Venture capital investors are not long-term investors. They want to see a return on their investment within 5 to 10 years, sometimes a little bit more, usually with a 20% annualized internal rate of return. That means they want to see overall growth of at least 20% a year in terms of their return on investment. So those are the differences between small businesses and tech. It's important to recognize this because their legal needs are very different. I said at the beginning that I practice in 36 different areas of the law, and the reason why I know it's exactly 36 is because I am the author of a legal treatise for Thomson Reuters. It's called Advising Small Businesses. There are exactly 36 chapters in this book, and each chapter, it deals with a different area of the law and just the information that you need to know to answer the most basic questions that a small business client is likely to raise, in those 36 areas of the law. Here are some of the things you have to know a little bit about. One of the key things you need if you're going to practice in this area is a database. I use the term Rolodex. It's a very dated term, of course, but a lot of you use Google Contacts or something like that. But you want to develop a database of specialist lawyers that you can contact when one of your clients is asking for advice that's a little bit beyond your pay grade. And it's important, especially in the areas of intellectual property law, patents, and trademarks. I am not anybody's patent lawyer at all. That work almost always gets referred out to specialists. So here's what we're going to try to be talking about today. We may not get through all of this in the 1 hour that we have. I'm going to be focusing here on parts 1 and 3, organizing the small business client and financing the small business or startup enterprise. Be aware that when you represent a client, especially a tech, a startup enterprise, they will expect you to assist them in raising money. That is something you have to be prepared for when it happens. So let's talk about setting up the small business client. Somebody approaches you, they want to start a small business. You need to develop an intake form for the most basic information that you will need. At the very least, you will need the name of the entity. I always ask my clients for 3 choices, a first, a second, or a third choice, because sometimes their first choice is just not available. Then I ask for the business address, phone, and email for each initial owner. For a corporation, it's called a shareholder. For an LLC, it's called a member. The name, mailing address, social security number, date of birth. A copy of their driver's license or passport. This is not as necessary as it used to be. There's something called the U.S. Corporate Transparency Act, which some of you know about, that requires all small businesses in the United States to register within 30 days of formation. There have been some recent changes to that law that is only required now of companies that are foreign owned. But there is a possibility. There are some cases pending in the federal courts questioning the constitutionality of this statute. And if they do result in the statute being held constitutional, there's a possibility that the law may change back and you'll have to provide this information. And one of the things you have to provide under the Corporate Transparency Act is a copy of the driver's license of each of the principal owners of the small business. So it's a good idea to collect the information, even though you may not need to use it right now, rather than waiting for the law to change and having to go back and, to 80 different small business clients and ask them for their driver's licenses. It's going to be a very hassle thing to do. The percentage ownership that each owner is going to have, and also a 5-word or less of the business. These are the things you need in just about every state to file the paperwork necessary to set up the business. There are 7 steps to setting up a small business. First of all, you have to find a name for the business. Secondly, you have to determine if any business licenses are necessary. Thirdly, you have to decide on a legal entity, the type of entity. I mean, there are 7 different types of legal entity that you can use for a small business, but the most common, I would say 99% of the ones you'll ever deal with are either the regular or C corporation, the subchapter S corporation, and the LLC, the limited liability company. One thing, by the way, I want to get this off my chest. Every once in a while, I hear a call from some client client, sometimes from another attorney, saying that they want to form a limited liability corporation. You should be aware there is no such thing as a limited liability corporation. There are corporations and there are limited liability companies, and they are very, very different. And we'll talk a little bit about some of those differences later on. Fourthly, you then have to set up the legal entity by registering with your state. You have to register for federal, state, and sometimes city municipal taxes as well. You have to determine if the entity must register in another state. Here in the United States, we organize corporations and LLCs state by state. So if your client is doing business in another state, you'll have to register the corporation or LLC in the other state as well as the state of incorporation. And then last but not least, maybe file a beneficial ownership information report with the Financial Crimes Enforcement Network. If the company is foreign owned, if the company is more than 25% owned by non-U.S. nationals, you do have to make this filing with FinCEN in Washington. But if not, if they're all U.S. people or green card holders, you're okay. You do not have to do that, to take that last step. But if the company is foreign owned, you still have to do it. All right, let's go down to the 7 very quickly. Naming the business. Okay, these are the questions you have to ask. You have to get a little bit into trademark law here, but not too deeply. Is the company named trademarkable? If your client is looking to build a brand, especially a national brand, they're developing a consumer product, a new type of potato chip they're going to be launching nationally, whatever, that trademark is the most valuable asset that company is ever going to have. And if it cannot be trademarked with the trademark office in Washington, the Patent and Trademark Office, it is utterly worthless. It will not protect your client. I've represented clients who have made the mistake of not doing a thorough trademark search of the trademark records before they started in business. They launch their product, they do great, and then a year down the road, they get a nasty letter from some law firm in Idaho saying, cease and desist, you cannot use this name. My client registered the trademark long before you ever, you started using it in commerce. You can't use it anymore. You got to change your name after you've raised millions in venture capital and you're now in every supermarket in the country. Try doing that. It is not an easy thing to do. Has someone else trademarked the name? Do a trademark search. Does another company in your state have the same name? Corporations and LLCs are formed by state. If there is another corporation or an LLC in your state that has the same name, you probably will not be able to register the same name with the state. So check the state Secretary of State's database in your state and find out if there's somebody else with the same name. More importantly, can you get the right URL? These days, all business is digital. All business is the internet. Can you get the URL, and especially the .com, the top-level domain name for the name that your client wants to use for their products and services? If your client is Flibberty Gibbet Antiques, I expect them to be at flibbertygibbetantiques.com, and it will be a real negative thing for me in terms of credibility if I don't see them there. Okay. Secondly, do you need a license? Okay, here is Cliff's rule. If the client's business involves a product or service that has the potential to injure or harm someone if it is abused, the client probably needs a license to provide it. So, for example, professional services, lawyers, doctors, architects, alcohol, tobacco, firearms, anything to do with marijuana, cannabis, barbers. Basically, if anybody can hurt someone if they don't do their job right, there's probably a license somewhere at some level, usually the state level, that you have to get. Every state now has a licensing center. This is a website where basically all the state government agencies have gotten together and they've created an alphabetical listing of all the licenses that may apply to a particular business. So, for example, if your client wants to start up a barber shop, if you go to your state's licensing center and look under B for barber, you will probably, or maybe H for hairstylist, you will probably find the state requirements for barbers and hairstylists. But don't trust that it's up to date. These sites don't usually get updated very often, sometimes once a year, sometimes even less in some states. You still got to crack the books a little bit to find out exactly what licenses are required in your state. If your client plans to do business in other states, you may have to check those states' licensing centers as well. Here's a great web page. This is a great resource, by the way. It's a page on the SBA, the U.S. Small Business Administration website. And basically what it is, it's a map of the United States. You click on the state that you want to know more about, and it will link you automatically to the state licensing center website in that state. Really cool thing, actually. So if you have a client in New York that's looking to open up a branch in Iowa or something, all you got to do is click on Iowa on the map here, and it will take you right to the licensing center. Then always check with a local lawyer just to be safe. This is one of the reasons you keep in touch with your law school classmates in the hopes that, if you ever need an Iowa lawyer to just, have a 10-minute conversation with them, make sure you're not committing malpractice, you can call them and, maybe you'll buy them a beer or send them a gift basket or something like that. All right. Now let's talk about legal entities. We're up to part 3 now. So you found the right name, you know what licenses you need, and you've started the process of getting them. Now, do you need a legal entity at all? Now, believe it or not, even in today's litigious age, there are some businesses that don't need to have a legal entity. If your client is selling bobblehead dolls on eBay, for example, they probably don't. Lawsuits do not happen for that kind of a business. If a customer orders a bobblehead doll and the thing breaks in transit and the customer complains, there's not going to be a lawsuit over that. Your client is simply going to send them a new one. Or if they're out of stock, they'll refund the client's money. Or if they're really jerks, they'll blow the client off and they'll take a negative feedback hit on eBay, which is not a very smart thing to do if you sell on that site. Nobody buys from sellers that have negative feedback. But no, there's not going to be a lawsuit about that. So why does your client need a corporation or an LLC for a business like that? If the client is selling cars or vehicles on eBay, different story. If somebody orders a car on eBay, they go pick it up and the brakes fail on the way home, there's going to be a lawsuit about that. I always use this trade-off. There are 2 things that I want to know when a client we're talking about whether they should be a corporation or an LLC. I want to know how much protection against liability do they need? What's their risk profile? What's their liability risk profile? If they're dynamiting, homes and buildings, that's a high degree of liability risk. If they're selling bobblehead dolls on eBay, there's a very low liability risk. Where do they fit on that spectrum? I want to know something about that. The secondly is, how patient are they with legal mumbo jumbo and paperwork? Most of my clients find the thought of doing legal paperwork just totally offensive to them. There are some entities that do not require a lot of paperwork, but they do not give you the same protection against liability as the ones that require more paperwork. This is why I talk about it as a trade-off. The more protection against liability your client needs, the more legal paperwork and BS they're going to have to put up with. And they have to be ready and disciplined enough to do it or to hire you to do it for them. All right. Corporations give you great protection against liability, but they eat paper. There are things that must be done. And if they are not done, you lose the benefit of having the corporation. Okay. There are 7 or 8 different types of legal entity for a small business. I've actually given you a wonderful resource. It's included in the course materials here on Justia. It's called Demystifying the Business Organization. It lives on my website at cliffennico.com. It's absolutely free. It's a 7-page PDF file. Print this document out and sit down tonight with a strong VSOP brandy or other liquor of choice and just read the whole thing cover to cover. It'll take you about an hour to get through the 7 pages because it's pretty thick. It's pretty thick language that I have in there. But when you finish this and when you understand this 7-page outline, you will know as much as any attorney or accountant knows about the differences between corporations, LLCs, S corps, and the different other ways that you can form a business. It's a wonderful resource which I'm giving you for no additional costs. Okay. Because of that, I don't want to really go into a lot of the differences between LLCs, corporations, and S corps. I'd much rather give you the outline and have you figure that. If you took a course in business organizations in law school, you already know this. Can you use an LLC for an entrepreneurial startup, for a tech enterprise? LLCs are primarily designed for small businesses. They are not designed for tech ventures, but you can do an LLC for a tech venture. The only thing is you have to do a different type of operating agreement than you do for a small business. Sooner or later, a tech enterprise is not going to be an LLC. It's going to outgrow the LLC. It's going to become a C corporation, a regular corporation, because venture capitalists, when they invest in early stage ventures, they want preferred stock, and only the C corporation can issue preferred stock. That is the main reason. There's other reasons as well, but that's the main one. So when you're drafting an operating agreement for an LLC that's a startup venture as opposed to a small business, there are certain things you have to do in those operating agreements. You cannot refer to percentage interest, for example, to describe the ownership. You have to create units of membership interest, that translation, shares of stock that function like shares of stock. Basically, what you want to do in the operating agreement is you want to create a document that mimics a corporation's shareholder agreement, so that when the LLC ultimately converts into a corporation, if it's successful, you don't have to do a lot of work to convert the operating agreement into a shareholders agreement. All the provisions are right there. All you have to do is change the names on some things. So instead of units of membership interest, you're now going to call them shares of stock. You create a board of managers, wink, wink, board of directors, okay, with the same rights and privileges the boards of directors in a corporation have. You can have a preferred, you can actually have preferred equity, like preferred stock in an LLC. You can do that. It's a little tricky to draft, but you can do it. You know, you have a manager-managed structure with a board of managers, like a board of directors, and most importantly, a provision that allows the managers to convert to a C corporation at any time without getting the members' approval. They can do this at any time. Once the company is successful, they're starting to get venture interest from the venture capital community. That you do not want to waste time calling a meeting of 10, 15, 20 different members. The board has to move very, very quickly on that, and you want to make sure that they can do that without violating their operating agreement. I have a bunch of forms of these, by the way. It's a very special type of operating agreement. It's in another one of my Thomson Reuters treatises. I told you about advising small businesses before. This is another one. It's called Forms for Small Business Entities. It's published by Thomson. And all my treatises, by the way, are available by subscription. You don't have to pay them all at once. You can do a monthly subscription. You can do digital downloads and all that stuff. If you go to thomsonreuters.com, their legal publications section, you'll learn all about that. All right. So now we're up to step 4, which is setting up the legal entity. In every state, you have to file a certificate of incorporation if it's a corporation, or if it's an LLC, you file articles of organization. You file it with the state secretary of state's office. If it's an LLC, you must prepare an operating agreement. That's an agreement among the founders that has all kinds of rights and privileges. And if it's a corporation, you have to prepare bylaws, an organizational meeting of directors. You have to issue shares to the shareholders. Corporations are much more paper-centric than LLCs are. LLCs, you can do things very informally, but with corporations, there's a lot of paperwork involved. Everything's got to be authorized by either the board or the shareholders. And if you miss doing the paperwork, you miss the benefit of having a corporation or an LLC, which is limited liability. Be advised that some states, such as New York, require publication of a legal notice in a newspaper for LLCs. That's a step that can be a trap for the unwary. There are 3 or 4 states now that have this requirement, where after you file the articles of organization for the LLC, you got to publish a legal note, like a classified ad, in 2 newspapers in the county where the LLC is located. So just be aware that's an additional step that you may have to do. Step number 6, registering for federal and state taxes. You cannot use a social security number for an LLC or a corporation. If you're a sole proprietorship, you can use your social security number as a tax ID. It's a very bad idea, but it's not illegal. The IRS allows you to do it. But you have to get what's called a federal tax ID number, called an EIN. The EIN stands for Employer Identification Number, but you do not have to have employees. The client does not have to have employees to have an EIN. An EIN is nothing more than a social security number for a business. You register online with irs.gov. You file Form SS4. If you are creating an S corporation, there's an additional step that you have to do. You have to file IRS Form 2553 within 75 days of the corporation's formation. You can fax it to the IRS's office in Cincinnati, Ohio. You can't do it electronically yet, but you can fax it. If you have access to a fax machine, or if you're close to a UPS store or a Kinko's, you can fax the form to the IRS there. Some states, again, I reference New York because I'm admitted there, may also have to file a version of that form with the state tax department as well, if they have an income tax. So, for example, in New York State, you have to file both Form 2553 with the IRS and a form called CT-6 with the state tax department, which is basically the same form, in order to be exempt from state income tax. Otherwise, your client will not be exempt from state income tax. You will also have to register with your state tax department for sales tax if your client is engaged in e-commerce or any retail or wholesale type activity. They're going to have to register for sales taxes and other state and local taxes. If your client is going to have employees, and I mean W-2 employees, the owners, founders of an LLC are not considered employees. They're considered partners. They get a K-1 at the end of the year. They do not get a W-2. But if your client is going to be hiring employees from the get-go, W-2 employees, there's a whole nother set of tax registrations that you have to do at both the federal and the state level. My advice to most clients who are in that situation is to hire a payroll service such as paychex.com, that's paychex.com, or ADP. There's one called, I think, Gusto now, that's also very good, gusto.com. Get a payroll service involved, because these registrations are very complicated. Payroll tax withholding is a very complicated process. Even CPAs make mistakes doing this stuff, and lawyers. You do not want to be doing something. Your client shouldn't be doing anything that CPAs are having trouble doing. It's one of life's basic rules. Last but not least, does your client have to register in another state? The answer is yes, if your client has nexus, N-E-X-U-S, for tax purposes in the other state. Generally, in most states, nexus involves a physical presence of some kind. So if you have a client in Connecticut that's opening up an office in New York, that client has nexus in New York State for tax purposes. If your client is a landscaper and he's right on the border and he mows lawns in both states, he probably will have to register as a foreign entity in the other state where he's not physically located. A physical presence of some kind is normally required. It's very hard to generalize. Every state has very detailed nexus rules, but they all generally involve some kind of physical presence. So, for example, if your client is selling on Amazon and the goods and services are being stored in a warehouse in another state, and they're shipping from that warehouse and taking returns at that warehouse, they have nexus in that state and they have to register. Amazon will probably do the registration for your client. They do that for Kentucky. I know is one of their big states where there's a big Amazon warehouse in Kentucky, for example, and they will handle the withholding of taxes for the Kentucky Department of Revenue. But if your client has goods in a warehouse out of state and is using that as a business address, that's considered a physical presence. But no, if the client only has customers there, if you have a client based in New York who's selling goods to people in all 50 states, there usually is no nexus just by virtue of selling to people in that state, unless they are selling a lot of goods to residents in a particular state. The minute your client is selling more than $50,000 in goods, gross sales, to residents of a particular state, it's probably a good idea to check that state's tax laws, because a growing number of states now, there was a Supreme Court case in 2018 called the Wayfair case that allowed this. A lot of states are now imposing their sales taxes on out-of-state vendors that do a lot of business within the state. And the threshold is usually between $50,000 to $100,000 a year in annual gross sales. So if you see your client going over $50,000 in gross sales to a particular state, check the laws of that state and see if they have to register and start paying sales tax there. We call that a Wayfair tax. We're not going to spend a lot of time on the beneficial ownership information report. Last year, 2024, this law went into effect and it scared the heck out of a lot of people. It basically required all small businesses to disclose their beneficial owners to FinCEN, which which is an agency of the U.S. Department of the Treasury. Very, complicated. You had to post copies of the driver's licenses of anybody who owned 25% or more. They cut back on this law at the very end of 2024. It now only applies to businesses that have foreign ownership, significant foreign ownership of more than 25%. Any domestic LLC or corporation does not have to do this. Like I said before, though, this is kind of a political football right now. They may remove the law from the books. They may enforce it if it is found to be constitutional. There are a number of cases in the federal courts that are arguing over whether or not this is constitutional. And if they say it is, then FinCEN is probably going to try to enforce it again to domestic companies. So collect the information that you will need to do the filing now, and then hope that you'll never have to do it. All right. So let's talk here. So now let's shift gears. Now let's talk about ownership here. Corporations have three layers of management. They're more complicated than anything else. They have officers who conduct the day-to-day operations. They have directors that make big decisions that are outside of the ordinary course of business. And then they have stockholders, shareholders. Stockholders and shareholders means exactly the same thing. Some states call them stockholders, some states call them shareholders, but they're exactly the same. They make the big birth, marriage, and death decisions, basically, even if they're all the same people. So if Mo, Larry, and Curly form a corporation, they're all going to be shareholders. They're probably going to be all directors. And they're probably all going to be officers as well. It's very important when decisions are made at a corporation that it's being done at the correct level. Mo as a director can make decisions that Mo, the president of the company, cannot make. And it's very important to understand the different levels and make sure that decisions are made at the right level. Again, whenever a corporation makes a decision, there has to be resolutions done or something called a unanimous written consent. And that document must be signed by all of the directors or the shareholders or a majority of the directors and the shareholders. State law varies depending on the type of decision that is being made, whether it's a majority or 2/3 or 3/4 or whatever of the directors or shareholders that have to approve. LLCs, there are two types of LLCs. There are those that are managed by members, the owners, or by one or more managers. As I said before, if you're setting up an LLC for a tech enterprise, you want to set up a board of managers that functions much the way as a board of directors does. Okay. You will need to draft a founder's agreement. For an LLC, it's called an operating agreement. It is required by law in virtually all states, even for a one-person LLC that only has one member, and is prepared as part of the formation process. For a corporation, you do not legally have to have a shareholders agreement. They're optional, but they are highly recommended. And these are some of the provisions that you need to include. Voting and management provisions. For small businesses, restrictions on the founders. You don't want these people going and working for a competitor or running a competitive business. For small businesses, you want to have provisions that restrict the transfer of shares to people outside the family. Remember, one of the goals of a small business is to maintain ownership over the very long term, keeping everything within the family. We don't want strangers getting involved in this business who are not part of the management team that are running the business day to day. Just the opposite for tech startups, for entrepreneurial startups. There you want to have provisions that basically allow the majority shareholders to do whatever the heck they want and drag all the minority shareholders along with them. You do not want to have a situation in a tech company where a big transaction comes up. Somebody wants to buy them. They want to exit and get acquired by a bigger company, and a 1% shareholder has a veto power over that decision, that $1 billion transaction. That's a nightmare. You do not want to have minority shareholders in a tech startup having too much power, and there's different ways you can do that. Again, I refer you to my legal treatises where you can find forms for these things. All right, let's talk about money now. Last but not least, if you're representing a small business, and especially a tech startup, rest assured you will be asked to help them raise money. That is one of the reasons they are working with you. They think that attorneys know rich people. That may be true, that may not be true, but virtually all my clients think that I know billionaires. I do not. I'll share that with you. And if I did, I wouldn't want to refer a client to them that I haven't been working with for a very long time. So just listen, lest anyone get any ideas listening to this program. there are four stages of funding for small businesses and for tech startups. The first of all is the founders round. This is where the founders put in their own money. So Mo, Larry, and Curly are forming an LLC. Each one puts in $50,000 in capital to get the company off the ground. Okay, that's what it is. And by founders' money, I'm not just referring to cash contributions. I'm referring to money that comes into the company via the owners. So, for example, if Mo takes out a home equity loan and uses the proceed or an SBA loan and uses the proceeds of that loan to contribute to as capital to the company, that would be considered founders' money, even though the ultimate, lender is the SBA or a bank. So that's the founders round, and virtually all companies go through a founders round. When founders have to put money into the company, they do. Then there's the friends and family round. When the founders have exhausted all their resources, their credit cards too, that's founders money. If they're hitting up credit cards for the business, very common. Then they start looking for money from their friends and family, and we call this the friends and family round, where they usually borrow money. It's usually in the form of loans, but it can be an investment as well. It can be a contribution to capital. The important thing about friends and family offerings is make sure that you don't treat them like friends and family. Get the exact same paperwork from Uncle Joe that you would get from a venture capitalist. Do not treat Uncle Joe any differently. One of the biggest mistakes that a lot of small businesses make when they borrow money or take investments from friends and family, they don't document things carefully. So if things don't go the right way, Uncle Joe all of a sudden goes over to the dark side and now, thinks that he has more power to run the company than he actually has, and you don't have the paperwork to contradict him. Unfortunately, be very careful. Once a company starts making money, relationships have a habit of changing. Okay, and that's true in just about any small business that I've ever seen. I know that sounds a little cynical, and I apologize, but 45 years of working with small family businesses, believe me, friends and family get along great when the business is first getting started. But when there's money on the table, you start seeing a different side of people. Make sure you get proper legal documentation. Now, for small businesses, that's usually it. Most small businesses do not go beyond the friends and family round. If you're dealing with a startup, though, there are additional rounds of funding that go beyond that. Most startups go through an angel round. This is where they raise anywhere from $250,000 to $2 million from individual investors. These are usually wealthy individuals who either live in the same area where the company is, or they're in the same industry. They're usually networking contacts of people who run the founders. And they put in, between usually $250,000 to $500,000 each, to pay all the seed expenses that the company goes through. And then, if that work turns out to be successful, and especially once the company has launched its product and it has all its intellectual property protection, its patents and trademarks in order, that's when they can start doing one or more rounds of venture capital. And there's usually a seed capital round. That's a round that basically pays the startup expenses of the company. Series A, Series B. These are not legal terms. These are just terms that are commonly used in the venture capital community. But usually a successful startup will usually have one or more rounds of venture capital financing that are denominated by letter. There's Series A, Series B, Series C, and that's it. If an LLC, if a tech startup is starting as an LLC, you should convert it into a corporation before angel or venture rounds take place. Okay. You should also consider reincorporating in Delaware. There are a number of reasons for that, but the most important is that historically, up until very recently, remember I said before that tech startups are designed to be owned by both active and passive owners. They have both active and passive owners. Well, very often those active and passive owners have disputes with each other. And Delaware law has always had a historic tendency to lean very favorably in favor of the inside managers, the people that are running the business. In a dispute between the inside managers and the outside investors, you want to be in Delaware because Delaware law is usually going to be on the side of the founders. There's been some recent case law that has changed that lately. Some of you know that Elon Musk has threatened to remove his company from Delaware to Texas because he doesn't feel he's getting the protection that he should be getting under Delaware law, and Delaware is changing the law partly to accommodate that. So it's kind of a football right now, but still Delaware is a great place to be for tech startups. Most small businesses don't get beyond the friends and family round. And just make no mistake, you are going to be asked to help for this. Okay. We'll talk about this very briefly. Let's go through each of these, different levels of financing. The founders round, there's only two ways that you can put money into a corporation or LLC. The founders can either loan money to the company, or the founders can make a capital contribution or an equity investment. A loan means that they're lending money to the company and they expect to get paid back with interest over a period of time. A capital contribution or an equity investment does not have to be paid back with interest at all. The founders are simply putting money into the company in the hopes that they will be able to get a return on their investment through future distributions of profit. That's what they are. That's the difference between the two. There are a couple of three things you need to know here about the differences between loans and capital contributions. Capital contributions put a value on the company. If Mo, Larry, and Curly are setting up an LLC and Mo puts in $10,000 for 1% of the company, the Stooges have now put $1 million a value on this company. If 1% is worth 10,000, 100% is worth $1 million. So now this company has $1 million valuation, and that has consequences. Loans do not. Loans do not put a value on the company because the owners do not have an interest in the profits and losses of the business. All they get is their interest on their loan when it gets paid back. That's the only thing that a lender gets. An investor gets additional rights. An investor not only gets a return on their investment, they also have the right to participate in management, to vote at shareholders meetings and member meetings. They have those rights. Now, also, too, capital contributions must be pro rata based on ownership percentage, while loans do not have to be. So if Mo, Larry, and Curly are forming an LLC, Mo and Larry put $10,000 each. Curly also has to put $10,000 in if he is going to be a 1/3 member of the LLC. Okay, if the idea is that they're going to divide everything equally, then they must make equal contributions to capital. Loans, though, do not have to be equal. If Mo, Larry, and Curly are forming an LLC, Mo and Larry put in $10,000 each, but Curly doesn't have, the money to put in his $10,000. Mo could agree to lend an additional $10,000 to the company, which will give the company the $30,000 that it needs. Loans do not have to be based on percentage ownership. So, for example, it's very common to have a situation where A, B, and C own a company, and A has put all of the money, the startup capital, into the company because A has deep pockets. In a situation like that, it's generally a good idea to have A loan the money to the company, because if he does a capital contribution, it's going to throw off the other two members, and they will have a smaller ownership stake in the company than they were intended to have. Just always keep in mind that capital contributions, equity investments must be done based on the percentage ownership. If you're in a situation where you can't do it that way, then the members or the shareholders should be putting in loans. Okay. All right. Be very careful when a company has sweat equity founders. Let's go back to that example I did a couple of minutes ago. Mo, Larry, and Curly are forming an LLC. Mo and Larry can put in money to start the company, but Curly cannot. But they want Curly to have a significant ownership stake in the company, because let's just say, Curly is the technical genius who's going to build the software app. He's a tech genius. He doesn't have any money, but he knows a lot about technology, and he can build the software app that the company is going to launch. They want to make him a third member, but he doesn't have the money to contribute to the capital to the company. He is called a sweat equity partner or a sweat equity founder. You got to be very careful with these people. Once the company has a valuation event, okay, it can no longer issue founders shares for zero or low value. Okay. When a company is first starting out, let's say, when the company's first starting out, we don't have to worry about Curly too much. What we can do is we'll set the company up with $100 in capital. Mo puts in $33. Larry puts in $33. Curly can certainly put in $33. He can afford that. So he'll come in. They'll be a third, the way they want to be. And then the additional $250,000 that they need to get the company, to get the software app launched, Mo and Larry will make loans to the company for $125,000 each. And that's how they will capitalize the company. They won't do it as an equity contribution because that would dilute Curly's ownership interest, but they can make a loan. Again, loans do not affect the ownership of a company. All right. Also, too, sweat equity, if you don't do it right, you can get into serious tax trouble, especially for the person holding it. So let's say that in my example before, Mo and Larry have put in $10,000 each. Curly doesn't have any money, but they say, that's all right. We'll give you the 1/3 anyway. And they give him the 1/3 for nothing, for just his labor. The way the tax law works, it's Section 409A of the Internal Revenue Code. Come tax time, Curly is going to have taxable income of $10,000 that he is going to have to pay taxes on. All right. That's the value of the shares, the sweat equity shares that he got when the company was founded. Whenever, you give somebody a piece of a company and they don't pay money for it, if the company has a value to it, which in this case it would, a value of $30,000, Curly would have to pay taxes on his pro rata share of the stock, even though he didn't get any cash and he didn't put any cash money, and even though he didn't get any cash money in return for it, he has what's called phantom income, and that's not a good thing. If Curly doesn't have the money to pay those taxes, either Mo and Larry are going to have to bail him out, or he's going to have to cut a deal with Curly's going to have to cut a deal with the IRS to pay over the years. With corporations, there are a lot of ways that you can avoid this situation. There's restricted stock, options, warrants. You can do a phantom stock plan, cash payment on change in control. That's kind of an advanced topic that goes beyond today's pay grade. But just keep in mind that with corporations, you have lots of options. With LLCs, you do not. There's only one way that you can avoid an owner having phantom income because of a sweat equity investment, and that's something called a profits interest under these two IRS revenue procedures. Be very careful. You got to structure these very carefully. You may want to bring in the advice of a tax lawyer if you're in this situation. Okay. And then last but not least, whenever sweat equity owners receive shares with a vesting schedule where they don't get all their shares up front, but they vest over time, make sure they file something called a Section 83B election to minimize their tax liability so they don't get clobbered with taxes each time a vesting date occurs. All right. Friends and family offerings, sometimes it's the only way that startups can get capital. Beware of informal relationships. Get the same documentation you would get from an arm's length investor. Whenever you are in angel or venture capital land, the securities laws come into play. When it's founders' money, the securities laws usually don't come into play. When it's friends and family, they do come into play a little bit, but nobody really worries about it because they're friends and family. They have access to information that the general public doesn't have. But the minute your client starts selling shares or debt to people that they do not know personally, that's the big dividing line. Whenever they start selling their securities to people that they don't know personally, that's when the securities laws come in. And you've got to make sure that those offerings are exempt from registration under Section 5 of the Securities Act of 1933. Angel and venture rounds. The thing about angels is that there are good angels and bad angels. And you got to make sure that your client understands who they're dealing with. It is a big mistake to accept money from somebody who has a hidden agenda, and sometimes they do. Be very careful. Investors always ask for the moon, the sun, and the stars, but there are a lot of people out there that can put $250,000 into a company that cannot afford to put $1 million into a company. And one of the biggest mistakes I see my clients make who reach this stage of development is they give too many rights to the early stage investors, which prevents them from raising money from the bigger investors down the pipe when they need, instead of needing $250,000, they now need $1 million or $2 million or $5 million. You do not want to give early stage investors too many rights so that they can veto or block a bigger offering later on. Be very careful. Also, too, some angels may have a hidden agenda. If you are dealing with any kind of a celebrity or, any kind of celebrity or, someone who's, Hollywood movie star, sports figure, basketball star, whatever, make sure you find out what kind of a promotional opportunity they're expecting to get out of this. They not only want to invest in your company, but they want to promote this. And let's face it, you want them to do that because they've got a social media following much bigger than anything you're ever going to have, but they may want some things in return for that you don't want to give them. So always find out what the hidden agenda is. There usually is one with a thing like that. And maybe they have a crazy cousin they want you to hire for the company because he needs a job or something like that. I've seen things like that happen. Okay. Again, make sure, and by the way, when you start getting involved in securities law, make sure you are covered for that on your malpractice policy. Not all malpractice policies cover securities law work. Okay, last but not least, crowdfunding. I've written a whole book on this topic. It's called The Crowdfunding Handbook. This one's not Thomson Reuters. You can get anywhere books are sold, Amazon, wherever. In 2016, the SEC developed a set of rules that's now called Regulation Crowdfunding that allows small businesses and startups to raise up to $5 million a year through an online crowdfunding portal that has registered with both the SEC and FINRA, the Financial Institutions Regulator in Washington. 95% of crowdfunded offerings are on one of these three sites: WeFunder.com, StartEngine.com, and Republic.com. These companies specialize in crowdfunding offerings of securities. Offering documents have to follow strict guidelines. Basically, what you do is you create a set of investment documents, you post them on the portal, and then you tell people that you know that they can make an investment on the portal. Everything has to happen through the crowdfunding portal. You can't raise money on the side. Once you post your offering on a portal, everything has got to happen through all communication with the investors. Everything, all advertising has to take place through the portal. It's best suited right now. It really hasn't taken off. I'll be very honest with you. We all thought back in 2016 that this would be the next wave of small business financing. It hasn't worked out that way. They're best suited for businesses that aren't likely to attract traditional venture capital financing. So let's say that your client is a small business, a traditional small business, but they have a huge following on social media. They have 1 million likes on Facebook. They have 500,000 followers on X. This is a company that could possibly do crowdfunding and actually raise equity capital from people that they don't know, but who are already fans of the business. They would create offering documents, post them to one of these three portals, and then send a blast message to all of their social media followers saying, hey, you love our company, you can now get a piece of it. Go here to the crowdfunding portal to find out more. They can do that. Breweries, liquor and cannabis, for some reason, are big players in the crowdfunding markets. Craft breweries, distilleries, small retail service businesses with huge social media, a lot of entertainment. I actually have a client right now that's doing a crowdfunding for a Broadway musical. It's a jukebox musical based on the music of a 1980s era rock band. I won't mention names. It's a band that you probably have heard of if you're a fan of 80s music. It's a musical based on their music. And what the goal is here is that they will leverage the social media following of the band, which has millions of followers worldwide, to raise money for this jukebox musical on Broadway. I won't say anything more about it because I don't want to get into trouble. Just keep in mind that if your client does a crowdfunding and it's successful, you now have a thundering herd of investors who are not sophisticated people and are going to call your client every day wondering how their investment is doing. Whenever a client wants to do a crowdfunding, my first question is, what portal do you want to register with? My second question is, who on your team is going to be the investor relations person who's going to deal with the hundreds of emails you're going to get from your people, if your offering is successful. All right. So that's basically it. This is kind of a whirlwind tour of what you need to do. I could do a much longer program, but I think in an hour you have the basics. Here are some of the books that I referenced in my presentation, which you can resort to for more information. And here is where you can find out more about those books, by the way. These are links to the Thomson Reuters site where you can find out more about my treatises. My general interest book can be found anywhere books are sold. And here is, last but not least, where you can find out more about me. If you want to reach out to me and send me an email, that's perfectly fine. I welcome that. I may not get back to you right away. Do not expect a quick response. I'm getting over 100 emails a day that have to be responded to. But if you have a question, send me an email. This is how I learn about new things that are going on in the marketplace, and that makes me a better lawyer. So send me an email, and if I can't help you out, I'll try to point you to a resource, not necessarily one of mine, either a book or another lawyer who might be able to help answer your questions. So with that, Nina, we are done. And I think we're exactly at 1 hour. So thank you all for spending time with me, and good luck to you in all your practices. I hope I hear from you at some point.
Awesome. Thank you so much, Cliff, for all of your insights on representing small businesses and startups. Now, without further ado, we can go ahead and take some questions from the audience. I believe we have a few minutes. All right. So let's see.
Why don't you let me take over here, Nina? Because I'm afraid I've only got a couple of minutes here. I booked another call after this one. Let me ask could the tax considerations between an LLC and an S corporation be evenly balanced? How would you advise clients to choose? This is by far the most difficult choice of entity, is between the LLC and the S corporation. The S corporation has a number of restrictions on it, which will prevent it from growing too much. So, for example, if your client has at least one foreign founder, a non-U.S. founder, they cannot be an S corporation. S corporations must be owned by U.S. citizens or green card holders. So keep that in mind. As far as the tax considerations are concerned, the LLC and the S corp are pretty evenly balanced. If the client is going to grow rapidly during the first year, there are certain advantages to being an S corporation or being taxed as an S corporation. If you're not really sure what to do, you can form an LLC and have it taxed as an S corporation, as if it were an S corporation. So that might be a nice compromise until the client gets a little older and they know what they're doing. Second question, are there particular industries or business models where usually a traditional C corporation still makes the most sense for small businesses? Well, the answer is, for tech startups, it's the preferred way to go. The reason why a lot of tech startups don't start as C corporations is because C corporations cannot pass losses through to their owners. Okay, if you do, let's say it's a software company that you're starting up, software companies generally do not make money the first couple of years that they're in business. They're going to lose money for tax purposes. Now, if you're an S corp or an LLC, the company can pass those losses to the owners so they can take it on their personal tax returns. But with a C corp, you can't do that. Now, if your client is forming a business where they're going to make lots of money during their first year, then there are advantages to being a C corp. At that point, you can save money on your taxes by doing it that way. But that's it. There's really no particular type of entity. Sooner or later, if you're doing anything that venture capitalists are going to be interested in, sooner or later, this thing is going to be a C corp, and you have to prepare for that eventuality down the road. How early in the startup process should lawyers help clients engage a securities law specialist if crowdfunding is being considered? Okay. Here we're talking about a company that's going to be doing crowdfunding, okay? And when do you have to get a securities? The good news is the 3 portals that I mentioned in my presentation all have staffs of attorneys who will help you do it, because the way the law works is they are liable if something goes wrong, okay? If an offering is posted on their portal and there's fraud involved, they are the first line of attack for the SEC or the government to go after. So they are very motivated to make sure that doesn't happen. So don't be surprised if they will actually offer, and I would take them up on that, to have one of their attorneys develop the crowdfunded offering documents. Take advantage of that. They're tremendous resources, and yes, you'll have to pay for them, but it won't be your malpractice policy. It'll be theirs. Otherwise, my advice to you is my bottom line is whenever your client is offering their securities to people that they do not personally know, people with whom they do not have a prior relationship, you need to get a securities lawyer on board or become familiar with securities law yourself. I will be doing a program for Justia later this year on securities law for the general practitioner. That's a program that you might want to sign up for. I think it's in September or October of this year, but anyway, check the listings because that is a program that I do, and I'll sort of give you enough information so you can figure out if it's something you want to handle yourself or whether you want to bring in a specialist. So that's basically it. I'll do one more and then I really have to run. What are the most common pitfalls you've seen in poorly drafted operating agreements for LLC, and how can a lawyer proactively avoid them? I could really do a whole program on that, to be honest with you. The most common pitfall that I see is using a generic form. There are lots of forms available online. Most of them, comply with the statutory requirements of your state, but they're not good enough for your client. No two operating agreements look exactly the same. There are some operating agreements where you don't have to worry so much about putting a non-compete clause in. There are some where you absolutely have to put a non-compete clause in. There's all kinds of things. Get yourself a good treatise on doing LLC operating agreements where they give you different forms of things so you can look back and forth and see when certain provisions are appropriate and when they're not. It's something you're going to have to learn about when you practice in this area. And of course, I have a number of resources available for you, but I won't overly sell them right now. But anyway, so I think we've covered all the questions. Again, thank you very much for having me. And Nina, it's always a pleasure to do work for Justia. You're a great outfit, and I always enjoy doing work for you. And hopefully, again, you have my contact information. Do not hesitate to reach out to me, and I'll certainly be willing to help you if I have time. I'll be willing to help you in any way I can. So thanks again.
Thank you so much, Cliff, for answering our audience questions. And thank you all so much for your questions. We want to thank you all so much for joining us for another Justia webinar. I wanted to remind you all, as I did at the top of our presentation, of the services available to you through our website platform, Justia Elevate. It is our powerful WordPress-based website solution that has built-in AI tools like the AI-powered Justia Chat. Justia Chat makes it easy for law firms to connect with website visitors through friendly, approachable chat that collects potential client core information without any hassle. It also gives you the flexibility to toggle it on and off depending on what your scheduling needs are. And the best part is, after the chat session is complete, you will receive a clean, summarized version sent right to your email so you don't have to sift through transcripts. Stay ahead with legal tech and stay in front of the eyes that matter. Learn more at elevate.justia.com. Or if you've got other questions, please feel free to give us a call at 888-587-8421. And have a wonderful rest of your day. Thanks again for joining. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.